Good morning. I hope everyone had a great weekend. Now we're back to spring weather. Today is Tuesday, March 24th, 2025. Welcome to the First District Court of Appeals. It's an honor, privilege, and pleasure to be with you here this morning. We have two cases that are scheduled for argument this morning. We have three cases that are on the docket. So the first case we have that's on the docket that is not arguing is case number C240341, State of Ohio, Roger Hildebrandt. That case has submitted on its brief. The next case we have that will be arguing this morning are cases number C2404787980818283848586878889. I could have said just 79 to 89, really. In Re AB, if counsel can please identify themselves and their readiness to proceed.
Jessica Monson, Will Porter, on behalf of the Appellant, AB, ready to proceed.
Good morning.
Norma West, on behalf of the Appellee of the State of Ohio, ready to proceed.
Okay, and who's this gentleman with you?
This is Will Porter.
Okay.
He's an intern with our office.
Okay, all right. And the next case we have is cases number C240682, 250042, in Re D Children. I understand that Attorney Fantetti is the only one. Did I say that correct, Fantetti? Okay. I understand you're the only one that will be arguing this morning. Is that still correct?
That's my understanding as well.
Okay. And you will be arguing on behalf of Mother as Appellee.
Yes.
Although I think there's a cross appeal as well, right?
There is an issue raised on Appellee's side.
Okay, all righty. All right, thank you. All right,
That father did also do it.
yes. All right, so we're going to start off with in Re AB.
I reserve 3 minutes. Good morning, Your Honors. May it please the Court. Jessica Monson, Will Porter, on behalf of Appellant AB. The issue here is the juvenile court's failure to merge 12 counts of inducing panic for purposes of disposition because all 12 counts were allied offenses of similar import that arose out of the same incident. And the nature of these 12 charges, all being identical counts of inducing panic, separates this case from other cases. And the reason is because for inducing panic, it requires harm to a public, a group of people. There cannot be inducing panic to just one person. And so this separates inducing panic cases from other charges that are specific to a crime against an individual person.
What would the individual charge have been if they had just decided to charge it differently in the plea?
They didn't talk about different charges. It was just the initial charge was conspiracy to commit murder. Then there was a plea agreement to these 12 counts of inducing panic.
What was the maximum sentence on the original charge?
I apologize, Your Honor. I'm blanking on what that was off the top of my
Was
head.
it a felony of the first degree?
It was a felony of the first degree.
And this got dropped down to a felony?
Felony of the second degree,
Okay,
which would have had a minimum commitment of 1 year.
thank you.
And the reason for inducing panic only, involving multiple people and being required to involve multiple people, that is why when you look at the plethora of case law regarding inducing panic cases, almost every one of those cases only involves one charge of inducing panic where there's harm to multiple people. And in the very limited
I think what's interesting here is that it was amended to multiples pursuant to a plea agreement. And you know that in other areas of the law, there's any flaws that in essence gets, in a way, waived, because one can plead to anything as an amended charge and so on. Some people plead to facts that aren't even the true facts of the case. So how does that go into the calculus?
Well, I think this still fits in with inducing panic. There was a threat that was disseminated to not only to the 12 individuals identified, but to the rest of the school. There was panic to the entire school, and that was indicated in the state's memorandum. And when the state investigated this other adult male in Colorado, even the state realized that this other adult man didn't have the mental capacity or the means to bring guns, ammunition, anything else. So this was a threat where there was no means to carry out that threat. But the fact that there was 12 counts, there wasn't an error where defense counsel would have had to raise a problem with the complaint. The agreement to 12 counts was just to reflect the severity of the circumstances as a symbolic gesture. But as part of the plea agreement, there was no agreement or no indication from either side that this was intended to be separate offenses or that these weren't allied offenses of similar import. So in looking at, AB's juvenile record, it would show 12 counts, and so that was the symbolic gesture.
Did it go from 1 count to 12 counts?
It did.
And the maximum sentence on the one attempt count would have been 2 years?
I'm blanking on the initial conspiracy to commit murder, but the felony-inducing panic, because it involved a school, was a minimum commitment of 1 year. So that was all the juvenile court has the ability to control, was that minimum 1 year. And so the juvenile court split this into 2 separate groups, counts 2 through 7 and counts 8 through 13, and then ran them consecutively in the groupings to one another. But there was nothing to even distinguish that grouping 1 versus grouping 2 of what that was supposed to reflect.
Counsel, this hit list, did it just include names, or were there reasons why the individuals were listed?
There were, from the state's sentencing dispositional memorandum, there was copies of the text message exchanges. Individuals were listed, I believe one or two maybe didn't even have a last name, but it was a general idea to, put gas into the school, to knock everybody out, to cut the power to the school, and then the 12 individuals specifically identified where the threat of harm to those 12 individuals. But it was a generic threat as well to the entire school. The 12 individuals were just part of that threat.
But did AB give a reason why a particular individual was included on the list?
It was a general basis because AB was bullied and a friend of his was also bullied. And so AB, who suffered from autism spectrum disorder as well as other disorders, had difficulty with verbal communication and expressing himself. And so this was his way to express his frustration about this bullying that was happening to himself and a friend.
And I guess my question is, did the list say that, individual A is on this list because he bullied me in the lunchroom on this date, or a specific reason why each individual is on the list?
No, it did not.
Okay, thank you.
And so when we look at the different factors for looking at merger, the separate motivation or animus, there wasn't a separate animus or motivation. And I've gone over several of these, but AB did not have the means to carry out this threat. This person in Colorado was the one who was going to bring all these, was going to bring all of the items, was going to have to pick AB up.
Did the people on the list know he couldn't execute the threat?
They did not, and for this charge, that's what the panic was for the entire school community, was this fear of something potentially happening, even though AB, there was no way to facilitate this threat.
And is your argument that that fear wasn't particular to individuals on the list? In other words, would my reaction be different if my name was on the list versus me having some general association with the school?
I think it can be different, but what we learned from even the JC case is that you had a specific threat to one person and then a generic threat to shoot up the entire school, and that still encompassed. There's 2 separate adjudications, partially because it was a school and then for the economic harm, but only 1 sentence. And so even within that one dispositional sentence, there was different varying degrees of harm that can happen. And when we look at some of the other inducing panic cases, because it involves multiple people, even in those cases, you had varying degrees of impact to the different individuals, such as the case where person, was had to get out of her apartment, and getting gas was fired into the apartment. Other people in neighboring apartments also had to vacate, and the community was alerted. There was another case where individuals were held at gunpoint by the police and ordered to go to the ground, and one person was handcuffed. So that person had a varying degree of harm versus the other individuals, but it was all still one inducing panic, not only charged, but sentence or disposition. When we look at whether there was the separate harm, this combined threat was to the entire Marymount community. And we also know that each of these offenses was not committed separately. This was, again, one general threat that was disseminated to somebody at the school who then shared it with these 12 individuals. It was shared to the entire school. And that fits within inducing panic of something being circulated or shared with other individuals. That's how inducing panic happens.
I just want to make sure I understand something. I think that the heart of your argument is that although there's a hit list and although there were 12 people, that ultimately what the state moved forward on was an inducing panic to the school at large with 12 counts of such.
Yes, and the 12 counts was, like I said, is a symbolic gesture of those 12 people specifically named. They could have had 30 counts of inducing panic and still only had disposition on one count.
Was the attempted murder the original count? Did it specify the victims?
The conspiracy to commit aggravated murder, it did not in the initial complaint.
So it was a conspiracy to commit aggravated murder combined with this other person somewhere else that was unindicted?
Correct. That person was not indicted, not charged. Investigation determined this person did not have the mental capacity or ability to travel here to carry out any of these offenses.
And the original indictment didn't specify any particular victim in the conspiracy. It was just a conspiracy to commit murder.
The complaint itself did not list those victims. Here, when we look at these inducing panic charges, these are all the identical complaints that all reflect the same threat to commit violence at the public place of Marymount High School in the same time frame, and Marymount High School and that community, including the students and teachers, was the public that was alarmed. And here, the juvenile court's failure to merge all 12 of these dispositions violated AB's constitutional right against double jeopardy under both the Ohio and the United States Constitution. If there are no further questions right now, I will reserve the remainder of my time.
Okay.
Thank you.
Extra minute.
What, Your Honor?
You have an extra minute, so
Thank
you'll
you.
have 4 when you come back. Good morning.
Good morning, thank you, and may it please the court and opposing counsel. If there's no immediate questions, I'd like to talk about what I think actually happened in this case, because as I understand Appellant's argument, there's really been what I would describe as a revisionist view of what actually happened in this case. For example, Appellant argues that the 12 counts in this case were just merely a gesturing at the severity of the circumstances. To be clear, there was an original charge to complicity in murder, and then it's not as if that one individual charge was amended. The state brought 12 additional counts representing the 12 victims, explicitly representing those 12 victims that were named in the hit list. I believe
But they brought that as part of the plea agreement, right?
Correct. I think that realistically what they could have done is brought, for example, 12 individual complicity to commit murder charges, but given the fact that they were engaging in plea agreements, they created what we've represented in our brief as a legal fiction in order to affect this in order to affect this plea. But it all, go ahead. Sorry.
My question, so what was the benefit for AB? It went from
F1.
an F1 to an F2, multiple F2s, right?
Correct.
And the maximum sentence on the F1 would have been?
I'd have to look at exactly as it lays out because the juvenile.
Because it seems like it went from one charge with a potential maximum charge to many charges, which could be then run consecutive.
Correct. I think my understanding, at least as I read the transcript, is that the parties were going to agree to the 12 counts representing the 12 individual victims, and then they were going to make their arguments to the court as to whether or not merger was appropriate. And so the understanding from the juvenile, or at least the juvenile's expectation, was he hoped that his argument would be successful as to having the charges merge. I mean, I can't speak specifically to what was going on in the juvenile and in the defense attorney's head. But obviously, I think at all stages, and this is why I refer to this as a revisionist view of the facts, at all stages of the proceedings, these 12 victims were treated as separate and as individual victims representing in these 12 individual counts. That's true in both sentencing
I
memorandums.
understand that, but ultimately, there were 12 counts in which the victim was Mariemont High School, right? Is that what I'm understanding?
I disagree
Okay,
with
so-
that. Opposing counsel has pointed to the fact that Marymount High School is listed. It is not listed as a victim. The reason that it is in there is because the F2 portion of the inducing panic requires that a specific public place be named. In other words, 2917.31C5, which is takes an inducing panic up to an F2, requires the place at which the inducing panic is taken place is to be a school. So that is the reason that the school is listed in the complaint, not because it is listed as the victim, but because
Now, when you say the complaint, are you referring to the initial complaint?
no, I'm referring to the complaint on the inducing panic,
Okay.
which is what opposing counsel references when saying. I mean, ultimately, the way that I understand Appellant's argument is that in order for a court to make a decision on merger, their argument would presume that the only thing you're allowed to look at is the four corners of the complaint or the four corners of of the revised code when determining whether or not there is a separate conduct, import, animus. But that has never traditionally been the case, specifically because the law allows the court to look at more the whole of the case in order to determine whether those three elements are being met.
Right, but it's still within the confines of the charge itself. So this is where it becomes interesting. So
Right.
while you're right, especially when you're looking at import, you're looking beyond the complaint. But you're still going to be limited to whatever the agreement was. Not only does the accused potentially give up things, the state can also give up things pursuant to a plea agreement.
And I don't think either of the parties gave up anything in terms of whether or not there was to be a determination. I think explicitly the parties went into this understanding they were going to make their arguments as it relates to merger. So I don't think the state or the defendant conceded that there was only one victim. In fact, the state pretty explicitly said in its sentencing memorandum that we're doing this because of these 12 victims. And to be frank, I think the court treated them as as there being 12 victims through the purposes of these charges. I mean,
Were the victims all treated the same for the purpose of Marcy's Law throughout the litigation?
They were, Your Honor.
Has a place ever been treated as a victim for the purpose of Marcy's Law, to your knowledge, or does the state ever do that in a like situation for inducing panic at a public place?
My understanding, I'm not exactly sure about inducing panic. I'd have to look at the definition specifically in the Ohio Constitution now as it relates to a victim, but I know that at least as part of my understanding of the way that the Hamilton County Prosecutor's Office treats, for example, like a store, like a Macy's or something like that, or a place for, they might get a representative if a place is to be considered a victim, or I wouldn't consider it a place, more of like an entity, like a corporation or a business, or in that case, maybe the school. So it's not necessarily the place so much as it is the entity that is at that place, like the school, for example. But as I was saying, I do think that all of those victims were treated in compliance with Marcy's Law throughout the course of this case. The record indicates that the state treated them such, notified them of all the hearings. They were all, in the record, which you'll have before you, shows that each of these 12 victims was asked to provide a victim impact statement. Many of them did provide a victim impact statement. They were ordered, as part of the disposition in this case, the court ordered a stay away from those individual victims named in that list. So to say now that throughout the purpose of this, the state has somehow conceded that there was only one victim just doesn't make any sense. I mean, frankly, I don't think it's contested that for the purposes of reaching a plea resolution, the state, as Judge Zayas, as you've pointed out, engages in creating these legal fictions in order to reach that result. I try to think about what leg the appellant's argument would have to stand on if, for example, instead of bringing these 12 inducing panic charges, we had brought 12 conspiracy to commit murder charges, naming those individual victims, and then amended those down. as I understand their argument, they would have none, because they would have to admit that those original charges were amended. Under that hypothetical circumstances I'm presenting, the court would have been well within their rights to consider, well, we're amending this down, yes, to an inducing panic for the purposes of facilitating a plea, but at the same time, these are still the victims of this case, and we're still going to treat them like that. And to that end, when we're looking at the import of whether or not an offense merges, there was 12 individual victims. Each individual victim provides a different import for those charges. So the court was not required to merge those charges together.
How did the victims in this case become aware that they were the specified victims as opposed to the place?
One of the victims, it's my understanding that the juvenile in this case disseminated part of his plot or plan to one of those victims. Once that victim got the police involved, they discovered the whole the plot of what was going on. And so while that plot was kind of being disseminated and police were learning of these names and reaching out to these victims, that is, I don't know to be certain how many of those individual students were told by that other student, but that's my understanding of how they became aware of what was going on. I think it was kind of in flux because a lot of information was coming in, both from the victims were sharing information, the school was sharing things, the police were reaching out. So I can't be certain how each individual learned of
And
the
at
plot.
sentencing or throughout, was Marymount High School treated as a separate victim? Was there like a representative from the high school?
One of the named victims on the list was a teacher, and so I think at most you could say that maybe that individual was representing the school in some sense, but I believe they were there in an individual capacity. To my knowledge, I don't believe that. I think there was maybe a school resource officer who was involved, but I don't know necessarily that there was anyone sent as like a representative of the victim from the school.
So I have just a general question. Pursuant to a plea agreement, can the state change the victim?
I would think so, yes. Obviously, it's going to, do you have a more specific question about?
That was it.
I guess in terms of, again, when we're talking about legal fictions about what can happen, I believe, yeah, I think the state could change, either named or treat someone else as the victim for the purposes of reaching a plea agreement. To your question, Judge Moore, you had asked whether or not there was a specific, I think it goes towards the animus involved here. I don't believe within the actual hit list itself or within the messages presented in State's Exhibit 1, it indicated a specific reason for each individual victim. But certainly, at the very least, looking at the state's sentencing memorandum, they do provide some information that there were different reasons that each of the 12 individuals were named on that list. Some of them, it lists of making fun of the juvenile for being fat and gay, or others because they have done horrible things to other people that didn't deserve it.
Where did that information come from? Was that part of the investigation after this was uncovered?
Yes. Well, I think after it was uncovered, it's my understanding that the juvenile was interviewed and provided reasons. They learned of how these individuals became a part of the list as part of the police investigation and as part of the juvenile's own admissions. I also believe that within some of the victim impact statements that were provided by some of the victims, they indicate, here's why I believe that I was a part of this list. I think some individuals indicated they weren't sure, but some said, I think this might have been why. But to be clear, I can't sit here and tell you that there's anything in the record that indicates like each, here's this person, and their individual. I do think there's sufficient information to tell that there was a separate animus as to each of these individuals. From what he told police, and I believe this is in the...
He being AB?
He being AB. What I believe AB put, what can be gleaned from his indication that was put in the state sentencing memorandum and in his own memorandum, he indicated that these are the 12 individuals, and he had a specific reason that each of those individuals was on the list. To the extent that opposing counsel attempts to phrase this as like a general threat to the school, that he just generally threatened to shoot up the school, that is not true. In fact, as you can tell from the state sentencing memorandum, from the text messages that he sent, in his own sentencing memorandum, he specifically made it clear to police throughout the course of the investigation he was trying to avoid harming anyone except for those that he believed needed to die. And so
And his plan was to knock everybody out except for the 12 individuals that he had targeted, and then kill those individuals.
Correct. As I understand the plot that was uncovered by police, I mean, obviously understanding that the person from Colorado that was determined not to have been someone who was capable of, but assuming that his plot had undergone the way that it was discussed with that individual from Colorado, they would have gone to the school at some point, the whole of the school would have been knocked out with some sort of sleeping gas or sleeping agent, and then they would have systematically taken out a number of the individuals named on the list. I do believe that there was a number of females that were named on the list that AB had planned to kidnap for other purposes. And that plot, I think, appears in the state sentencing memorandum as well. But ultimately, the goal was that of those hit lists, even if those individuals were being kidnapped, they would eventually be killed, is my understanding.
So the people on the list were going to be treated differently than the general school population.
Correct.
And then within the people on that list, there was going to be different treatment for
Correct.
those victims.
Again, and this again goes to the animus involved, and I think what AB admitted to, which is that he had a specific plan and reason for naming each of these 12 individuals. It wasn't even the case where it was like 12 individuals, all of which who were in this one class, for example, or 12 individuals on a football team. It was 12 individuals that he had chosen specifically. And I don't believe, other than going to the school, they shared anything that would lead us to believe that there was kind of a general animus towards the school. With that, I don't believe I have any other, unless the court has any particular questions, I don't believe I have anything else.
All right,
Great,
thank you.
Your Honor, if there was any legal fiction here, it was to these 11 other counts. But as I've indicated, there still has to be more than one person that is affected by the public to become the public. And the DW case, I believe out of the 7th District, even looked at the different terms and the definition of those different terms as to what qualifies as the public. And in that case, indicated just several of those individuals when the rest of the school community was not affected, that did not meet that element of inducing panic. Here, the state's disposition memo did not, they did not agree. They did not argue against merger. The defense made a merger argument in their own dispositional memorandum. At the disposition hearing, the defense asked the court if the court wanted defense to go through those arguments. The court said no. It was still the court's obligation, since there was not an agreement to whether these were allied offenses, to go through that analysis and to conduct a correct analysis. And here, there was no indication of how the court could separate any of these counts. Even in the victim impact statements, those are identified. Not all 12 individuals, even on the list, did victim impact statements. Marymount High School was even one of the victim impact statements. So, the school community, which is also reiterated by the state in their dispositional memorandum, is that the whole school community was affected. We are not saying this is one victim to one charge. Again, this was just a representation to reflect the gravity of what was going on and the fact that this whole community was affected by this threat.
Was the impact on the whole community different than the impact on these individuals on the list?
It's not clear. So there were several victim impact statements, not all victim impact statements, but the state said the whole community was affected. And that's where we go back to the other case where an individual, the JC case, where one person was directly threatened that she was going to be shot or hurt, and then there was a general threat to shoot up the entire school. That did not make a separate inducing panic just for the threat against her. She was encompassed with the entire threat to shoot up the school. And in that case, there was actually separate threats, not only on a school bus, but at the school where information was being shared at multiple different points of this threat, not only to shoot her, but to shoot the individuals at the school.
And did that case involve a plea agreement?
No, that case went to trial, there was conviction on both. That was because the second conviction was based on the amount of money the school had to bring other resources to the school for safety. But there was only a disposition on one of those two inducing panic offenses. And that's really the only case out there that I can find where there was an adjudication or a conviction on 2 counts of inducing panic. All other cases, when there are any other inducing panic, those have been merged, and there's no real analysis there. This one had somewhat of an analysis, but limited. And I think this is because inducing panic involves a group of people. It cannot just be inducing panic to one person, and AB did not agree to inducing panic specifically to one person. These would not merge. And the state agrees that the plan was at disposition to argue this merger issue.
But AB agreed to plead to 12 separate charges, is that right?
He agreed to 12 separate identical charges, where Marymount was the public place that was impacted.
And each individual victim was the subject of each individual charge.
It was, the number 12 came about because of the 12 individuals on the list really as a token to show what that was, but it was not specifically count 2 was for this person, count 3 was for this person. That was not identified at any point in time, nor did AB agree to that. The entire part of this inducing panic was the entire school. For those reasons, we'd ask that this court reverse the juvenile court's decision and remand the case back to the juvenile court to order that the 2 separate dispositions merge into one disposition. Thank you.
Thank you. Thank you both for your arguments this morning. We'll take the matter under submission, issue timely decision. Wish you both a wonderful afternoon.
Thank you.
Good morning.
Good morning, Your Honor.
You can come to the podium when you're ready.
Good morning again.
Good morning.
Your Honors, may it please the court, James Fantetti on behalf of Appellee and Mother. If there are no initial questions, I would like to begin with some of the key facts that began this case. The complaint arose in March of 2022 when DD was experiencing high stress and acting out aggressively towards another student at school. Mother testified that he was stressed about having to testify at his father's upcoming criminal trial. After the incident at school, Mother made the choice to keep him home the next day where he was safe. He was not a danger to others, and she was monitoring his condition. In the meantime, DD's school had also notified the agency, and they began an investigation. The agency believed DD's acting out was caused by a lapse in his prescription medicine, and it was their opinion that he needed to be placed in a hospital setting immediately. Mother got upset at their intrusion into her home. She had just been dealing with the agency for 2 years, and it was less than 2 months ago that they were out of her life. She was upset, and because she got upset, the agency decided that all 3 children were unsafe with their mother and obtained an emergency order for custody. This was done even though none of the children have ever reported feeling unsafe with Mother. Mother has never been accused of abusing the children and never has. Nevertheless, the agency believed then, and they still believe now, that they know better than Mother how to provide for her children. Well, the next 2.5 years of court proceedings demonstrated that they do not. Once in agency custody, DD's acting out intensified. and his brother, J.D., who had not been acting out before being in agency custody, also began acting out aggressively. Despite having access to medicine and therapy, both boys were now, while in agency custody, struggling with their mental health and acting out aggressively towards others and destroying property along the line. They were doing so poorly that when this case finally came before the judge on disposition in October of 2024, both boys were runaways, and the agency needed mother's help in locating them.
Counsel, let me jump in, because I'm struggling with the applicable statute here
Yeah,
that the Job and Family Services relies on. And my understanding is that they are relying on subsection E1 of that statute. Is that your understanding?
yes, Your Honor. I think E1 and E2 are really the only relevant factors, other than all relevant evidence.
But does the appellant reference E2 in their brief? Because I'm not sure it saw that.
No,
Okay.
Appellant did not, I don't believe.
And so E1, in my understanding, requires proof by clear and convincing evidence that the mother failed continuously and repeatedly to substantially remedy conditions that caused the placement in the first place. Is that right?
Yes, yes.
And continuously, my understanding is without stopping.
I would say so, Your Honor, yes.
Was there any period where the mother did substantially remedy the conditions that caused the placement in the first place?
Well, there were two initial causes, Your Honor, the mental health of PD and the mental health of mom, according to the agency, right? DD's mental health resolved itself on its own when he was released along with his brother from the emergency room about a month or so into custody. Both boys ended up in the emergency room after being removed from their mother, and then they went to foster care and group homes as was needed. So mother's, DD, he's still got an upcoming pending criminal trial. I mean, he's had a lot of trauma, he's had a lot of stress, and what he needed was his mother. This is,
Counsel, what were the reasons for the removal in the first place?
well, when they showed up at mother's house after the incident at school on March 17th, with DD threatening to harm himself and another student, there was a 241 kids call.
What
And
did
the
the
next-
case plan reflect at that time as to the reason for the removal? Do
Well,
you
there
know?
was, the interesting thing about this case, Your Honor, is there's no case plan that was ever adopted. This was and I've spent a lot of time with this statute trying to figure out the difference between a motion for permanent custody and a complaint. I think at the end of the day, you get to the same result where the first question is whether the children can be returned. And if you get past that question, the question is, what's the best interest for the children? And that makes sense because
Though
if
I
you can-
understand English, I want to make sure I understand what you said.
Yeah.
There was no case plan ever adopted?
No, because, well, and the agency didn't even file a case plan on
So
the
then
second.
how is the trier of fact, the court, going to determine whether, for example, the mother has substantially remedied the situation if we don't know, if there's no determination on what the situation is?
Well, in a temporary custody situation, you would have a case plan adopted, and then you would have the parents comply with remedying the conditions. In the agency's opinion, mother needed to be in therapy continually is the best that I can,
But there was no case plan that reflected such?
and no court order for her to receive medical treatment, no court order for her to be drug tested either.
But the
They-
mother did take steps to deal with her own mental health.
She did, absolutely. She was taking medicine. She was getting a monthly injection.
And the state says she was not consistent in her mental health treatment. Is that your understanding?
That is my understanding, Your
And
Honor.
not consistent is different from continual, right?
Well, I'm not sure what the court's asking.
Well, my understanding is continuously means always. So had she never dealt with her mental health, then it would be continuous.
Yes.
In this case, the state says she was simply not consistent,
Yes.
so it was not continuous. Is that right?
Well, it depends on how you manage your own mental health.
No, I'm saying, in this case, my understanding is the argument is that the mother was not consistent. So sometimes she did, sometimes she didn't.
Well, there were no outward demonstrations of her not being mentally lucid. They made the assumption, Your Honor, that she was not a fit parent from the beginning of this case because she's bipolar. She got upset when they showed up at her house, and she wasn't going to therapy as they thought she would.
But she was going to some therapy.
Yeah, she was going to some therapy, and she was taking medicine as she saw that she needed. Yeah, that's a big issue in this case, as I see it. Their justification for continuing removal while the case was pending, that she refused to participate in random drug screens.
And that was not part of the original concern, right?
It was not. That was something added on by the agency once the case was pending. And again, they didn't have a court order for that either. They didn't even have a reasonable basis under the Fourth Amendment for requiring her to get drug tested. And they are a state actor. They are an agency.
Should there have been a case plan in this case? Statutorily, did it require a case plan?
That's an interesting question, Your Honor.
There's a whole set of statutes that govern case plan and ultimately say that that's sort of, everything goes back to the case plan. So I don't know if there's, I know that this started with orders of supervision and later turned into something else, but.
It did not.
But, are you aware of any section of the statute that applies here that exempts this situation to the requirements of a case plan?
Yes, what I would say is if they were not required to exercise reasonable efforts, which they were, because you need a court determination that you do not need to exercise reasonable efforts. If they were not required to exercise reasonable efforts, then I would say they didn't have to do anything offering services. And that would be what the case plan is all about, the idea of reunification, what does the parents need, and what can the agency provide. My opinion of this case is they took the attitude at the beginning that we've had enough experience with the D children, and there was an insurance snafu, and mother did not get her insurance card. It was delayed, and when they found out about that, they determined that she was an unfit parent. And the other applicable statutes, I think, would be inadequate parent. What is a fit parent? And that is a parent that can provide basic clothing, food, and shelter and take care of the basic needs of the child. The agency made the determination that their mental health care was their responsibility, and they did so without a court order.
What was the source of the agency's concern about her substance abuse?
I don't know of any, Your Honor. There's never been a drug issue that I know of. They did bring up criminal charges of a DV that was dismissed. But in my understanding, that's not even relevant, Your Honor, unless they can show some causal connection. And that's in the statute and in Ray Burrell, I believe it is, Ohio Supreme Court. Otherwise, every parent with a fault is liable to have their children taken away if we don't show some direct harm to the children, right? Because anybody with an OVI, well, that's a fault. Is even a criminal. Even criminal conduct is not enough unless there's some direct connection between the fault of the parent and the harm to the children.
Now, counsel, the other concern I believe the state expressed was with respect to the children's mental health.
Yes, Your Honor, they have never reported feeling unsafe with their mother. Dee Dee was safe at home, and mother testified that he was good at home. It was when he was at school that he was having issues, so she kept him home.
And didn't the mother arrange for treatment with Cincinnati Behavioral Health?
She did, on behalf of Dee Dee, she did arrange for his treatment there. Yes.
Wasn't the agency's concern that mother's mental health, she was inconsistent with her own mental health treatment, and it was likely that she was going to, in addition to not being able to care for herself, handle the needs of children who had mental health issues?
That was their concern, Your Honor, but it was never demonstrated at trial.
Who did they put on to demonstrate? Didn't they put on at least some evidence from
They
it?
put on a caseworker and a couple therapists that said that the boys were in therapy. The caseworker is not a licensed social worker. All they basically, their whole point is she wasn't going to enough therapy. And I don't believe they have any constitutional right to require that without a court order. This is a state administrative agency who was violating parents' right to determine their own mental health and the children's mental health without a court order. Obviously, there are necessary cases where the parents, or whoever it is, we all know that, where you go to court and you get an order saying, here's the treatment. And I think that's where a case plan would have come in, right?
So, Counsel, you have about a minute left.
That went fast. I did want to touch on the SACWIS records, Your Honor. I don't believe, we admit CSEA records all the time. Child Support Enforcement Agency, that contains the financial records of whoever it is, right? So the privacy concerns here are outweighed by the legitimate need of justice due process.
Was the attempt even made to offer those?
3 times, Your Honor, I subpoenaed the records custodian, I subpoenaed the caseworker. These are 3 separate hearings. And then I subpoenaed the director, Michael Patton, of the agency. He failed to appear. Your Honor, I'm offended by that as an officer of the court. I am.
My sense was that you had the records, and they simply weren't submitted to the court.
No, I did not have all the records, Your Honor, and this was an ongoing duty up till October 24th. I had some of the records, the ones that I was going to use at trial. I had actually given a copy to them, their caseworker, and at the next hearing, that caseworker did not appear. I believe that the real issue here is why did they not return the children sooner, right? The reasonable efforts after adjudication, or before adjudication, this case should have been.
You're answering his question. You can
Yeah.
finish.
After adjudication, when the boys were out of the emergency room, no efforts were made to reconcile here, even though the entity overseeing their visits was saying that things were going great.
And before you conclude, are there any other questions from the panel? Okay.
So, Your Honor, I would ask that the decision of the juvenile court, Your Honors, would be affirmed on remand. I don't think they proved their case there. And I think that reasonable efforts should be reversed. I really do. And we should not shy away from admitting these records into evidence that they will prove their case if they did their job. Sunlight is the best disinfectant.
Thank you. Thank you for your argument this morning. We'll take the matter under submission. That's okay. There's no, you're fine. And issue a timely decision. And that concludes the proceedings for this morning. Thank you, Renata.
All rise. Court of Appeals, First District of Ohio is now adjourned.